Hello everyone and welcome to today's Mondac webinar in association with Stewarts, who will be analysing data on commercial fraud claims in the civil courts of England and Wales from 2024. This session will cover insights from that data as well as broader trends in the fraud space. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Alex J is a global asset recovery specialist who heads the contentious insolvency and asset recovery team at Stewarts, focusing on disputes arising from fraudulent conduct and distressed or insolvent situations, often involving allegations of breach of duty, misuse of powers, and dishonesty. Charlie Mercer is a commercial litigator and solicitor advocate. His focus is on cross-border commercial litigation and international arbitration, with a particular interest in complex fraud and asset tracing, financial services and securities disputes, and post-judgment enforcement. Now, before I hand over to Alex and Charlie to begin, a quick housekeeping item. You are able to submit questions to Alex and Charlie by typing them into the questions pane of the toolbar on the right-hand side of your page. We do encourage you to get your questions in and we'll endeavour to answer as many as possible during today's session. It's now my pleasure to hand you over to Alex and Charlie to begin. Thank you.
Thank you very much for that, Dan, and hello to everybody. And thank you more widely, I suppose, to Mondac for allowing us to run this webinar. You've already heard who me and Charlie are, so I won't repeat that, and we'll launch into it. Just by way of a little bit of background, Stewarts has been working with Solomonic for some time now to produce and analyse data regarding commercial fraud claims in the civil courts in England. We produced a report previously in 2023. We imaginatively called it Analysing Trends. And we are looking to produce an updated version of that report, which will happen a bit later this year. So what you're getting now is a preview, I suppose, of the findings we have. And the idea is we're going to keep analysing the data and producing these reports, and the longer we do that, the more interesting it should be, and we will hopefully identify interesting trends as we go. So what we're going to look at and cover in the course of this webinar is two things really. We're going to look at the data, we're going to look at what it shows, and we're also going to comment on recent developments in the space more broadly, the fraud space more broadly. Dan's already mentioned, if you have questions or comments, please do put them in the chat. And to the extent we know the answer, we will try our very best to answer them. The one further introductory point I just wanted to mention here is that what we're looking at here is civil fraud claims in the courts, so private law claims regarding fraud. And to address some of the pre-submitted questions we had on what that means, when we're producing the data, there's no single, as many of you will realise, there's no single fraud cause of action that gets pleaded. In contrast, I suppose, to an offence of fraud, which does exist on the statute books. But when we're looking at civil fraud, it encompasses a variety of different causes of action which involve dishonesty. So these are things like conceit, conspiracy, bribery, etc. And that's how we capture what we deem to be a fraud claim. So a dishonesty-based claim. And again, as many of you on the call will know, the standard of proof where you plead a dishonesty-based claim doesn't put you into the territory of having to prove matters beyond reasonable doubt, which is the criminal standard. It is still the balance of probabilities, but when you plead fraud, there is an increase in the level of scrutiny that the courts will typically apply before it will make a finding of fraud, because the civil courts are still slow generally to make findings about dishonesty. And of course, there are additional rules you have to follow if you want to plead a fraud or dishonesty-based claim in England, by contrast with some other jurisdictions. So those were a couple of the questions and comments we had at the outset of this exercise. So we're going to move into looking at the data now. I'm going to pass on to Charlie to talk you through how that data has been compiled, if that's okay, Charlie.
Yeah, good morning, everyone. It's a real pleasure to be here. So I'm going to give a short word on the data. And the first point to say is that it's mainly been provided by Solomonic, and I'm sure many online will be aware of it. It's a litigation analytics platform that analyzes claim form, judgment, and other data from claims in the UK. And it really is an invaluable resource, both for research projects like this, but also for litigation practice generally. And we're very lucky to have it, and I highly recommend it to everyone who practices in the UK. So the data in this specific report is mainly based on two categories of data held and processed by Solomonic. The first is judgments issued from 2014 onwards, and this is a complete data set. The second category is claims issued since 2020, and this is a more nuanced data set. So claim forms are only available to the public and to Solomonic where all defendants have acknowledged service, or there's been a public hearing, or there's been a judgment. And this accounts for about 45% of all claim forms. But it's assumed that that 45% is representative of the wider population, and the remaining 55% have settled or been discontinued. So for that reason, the most reliable way to look at trends, in particular for claims issued, is to look at how the percentage of fraud claims changes over time. So that's why we're going to focus here on the percentages rather than necessarily the exact number of fraud claims, and that will become apparent a bit later on. And also, when we're looking at the number of claims issued, we have two measures. One is fraud claims as a percentage of all claims, and also as a percentage of claim forms that have actually been analysed, which perhaps gives a slightly truer reflection of how many fraud claims there have been. That might sound like a slightly technical introduction, but it's just to give you a bit of context, and it'll become a bit more apparent as we actually look at the data in a second. Aside from those bits of data that Solomonic have produced, we Stewarts have reviewed claim forms that are available in the relevant years to seek to identify data regarding the origins of parties. That data comes with notes of caution, but we'll come on to that a bit later when we come on to that section. And my final sort of introductory point on the data would just be stepping back. Our view is that our analysis is a point of difference to what's come before. So firstly, we're specifically looking at fraud claims rather than a more general study, which there are several others. And also those general studies tend to focus on judgments. And the problem with judgments is that they have an inherent time lag given the distance between a claim being issued and judgments being produced. That time lag can be several or many years in some cases, whereas our data primarily looks at claims issued, so we see it as much more current, and albeit there are assumptions that need to be inbuilt into that data. But yeah, so we see that it has that point of difference. So Alex, I'm going to hand back to you to talk about some trends.
Great, thanks, Charlie. So yes, looking at the data, we're going to look at the volume of judgments. I appreciate what Charlie just said about judgments, but we do still look at that. We are going to look at the volume of judgments where fraud was a pleaded issue, and then we're going to look at the volume of claims issued. And you can see, hopefully, on your screens the slide which tracks in a chart the volume of fraud judgments. I mean, there's a fairly obvious trend that arises from this, which is that if you were to draw a median line on this chart, you can see that the number of judgments over time where fraud is an issue has increased. And it will be interesting as we move into future years to see how far that increases. Obviously, there was a slight uplift as against the previous year in judgment citing fraud in 2023, and there was a slight reduction in 2024. But again, if you look at the data as a whole, fraud being a feature in a case that goes through to judgment is on the increase. If we move on to the next slide for data on claims issued, please. So You can see the data that we have here, and as Charlie's explained, we look at it in two ways. The first chart on the left-hand side talks about the number of fraud claims issued in total, and then the figure on the right-hand side of the page talks about the percentage of fraud claims where the claim form has been analysed, where we've been able to have access to it in the way that Charlie has explained. The overall point to make here, and of course the volume of fraud claims issued only goes back to 2020, is that in broad terms it tracks the fact that over time, and certainly from 2020 onwards, on the previous slide in relation to judgments, the number of claims involving fraud has certainly been on the up. And broadly speaking, if you look at the percentages, and I'm just going to look at the chart on the right-hand side for number of claims analysed, in the last few years, the percentages have been around the 10 to 12% mark. It's 11% for 2024. It was slightly lower in 2023, but it's broadly maintaining its volume in terms of the number of claims where fraud is a pleaded issue. And we could debate the reasons why it might be that fraud is at the moment being pleaded slightly more often than it has been historically. One reason is perhaps there is a greater willingness on the part of parties to plead fraud, although of course in England and Wales certainly, as I mentioned before, if you're going to plead fraud, you do need to have good and cogent evidence to do so. The other factor that's fairly obvious is that perhaps there is an increase in overall fraudulent behaviour. There's lots of different points that have emerged over time, both in terms of the global economic and political landscape we face at the moment, and economic and political instability pressures are a driver of fraud typically. So it could be that those are factors that are at play, and given the current environment that we're in at the moment, which in terms of global political conditions is less stable than it has perhaps been in prior years, one might expect that there would be an increase in fraud claims as a result, and we'll see if our data starts to bear that out over the coming years. I should say as well that broadly what we say in this section here tracks the commercial court's certainly own data in terms of the prevalence of fraud claims. The commercial court does produce its own data, so it does also track that. And the final point I'd make is that, as Charlie's alluded to, we look at the volume of fraud claims in two ways. We look at the chart on the left-hand side of your screen, which is total fraud claims issued, even when we can't see the claim form. And we look at the chart on the right-hand side, which gives the percentage for claim forms that become available because the claim is actually progresses. And there's obviously a disparity in terms of the overall percentage there. Perhaps the commercial court's own analysis of the number of claims where fraud is an issue, maybe a slight underestimate. They put it at something like 3%, certainly for 2023. So again, perhaps there is in fact a greater use of fraud overall in pleading cases, which is hopefully helpful. If we move on to the next slide, please. So this tracks the data for the preferred courts where fraud claims are brought. And you can see it tracks by year, which court was the preferred court, as it were, for pleading fraud claims. In our previous report, and this was going back to 2023, although using data that went a bit further back into 22, you can see that the commercial court was the court of choice, I suppose, for pleading fraud claims. across 23 and 2024, that picture has changed a little bit. The data suggests that certainly in 2024, the King's Bench Division was the most popular court for bringing a claim where you're pleading fraud. There's also been, a proportionate increase in claims pleading fraud in the Circuit Commercial Court, which is, of course, a court that has lower thresholds in terms of value where cases can be brought. And again, this data does track the data produced by both the Commercial Court and the Circuit Commercial Court. It broadly accords with them. So we think this is giving a fairly accurate picture of the courts where fraud claims are being brought. And we can speculate a little as to the reasons for this. I think the most compelling reason for the shifting percentages where claims pleading fraud are being brought, and of course, if you remember, this data is all effectively relative to each other in terms of the percentages. If there's a reduction in fraud claims being brought in one court and other courts remain stable, then you'll see an increase ultimately in the percentage of that other court. And what it would suggest is that there's an increased proportion in the last couple of years of lower value or perhaps less complex fraud claims that are therefore being issued in the King's Bench Division as opposed to, for example, the Commercial Court. That is what that data would suggest. And actually, if you look back on the previous slide, and in fact, can we just switch back to the previous slide on, can you go back one further, please, to claims issued? One further on. Thank you. If you look at the volume overall of claims that have been issued, you can see, there's ever so slightly a drop off in previous years, certainly in 2024, as compared to previous years. That's on claims analysed. And if we move forward again, please, to the next slide, perhaps what is happening is the reduction in claims being issued is actually a reduction in claims being issued at the higher value end. And that may be a driver which is producing these metrics showing that the King's Bench Division proportionally is the court where more claims are, fraud claims are being issued. So, that's one area that we could look at. Perhaps another interesting feature of this analysis is that there's also a higher proportionate number of fraud claims being brought in the property trusts and probate courts, which has increased a little. And we could again speculate about the reasons for this. I know colloquially, at the very least, our trusts disputes team are very busy. And one of the drivers of them being very busy at the moment, and they expect to be very busy going forward, is that we're in a phase where there's a significant amount of wealth transfer, particularly over in the Far East at the moment. And of course, whenever there's a transfer of wealth down to other parts of the family members, that can in some cases cause dissatisfaction between different factions, and that drives disputes. So perhaps we are seeing an increase in claims in that area where, of course, people are pleading fraud. This is speculation, but we have to work with the data and look to see trends. We will obviously run this data again in years to come, and if we're right that fraud is going to be on the increase, one would expect that to feed through to the higher value end of the market, and maybe we'll see a resurgence, I suppose, in the commercial courts and perhaps the business list as well. Charlie, I think that's enough on volume and preferred courts. Do you want to take people through the sector's data?
Yes, I do. And here we are. We have a slide on our screen. And what you can see here are graphs, pie charts showing what proportions of claims fall into which sectors. And just an explanatory note on these graphs. So sector data is based on whether at least one party operates in the specified sector. So that means that some claims may be double counted depending on the parties. So if you had a financial institution and say an IT company in the same dispute, they would both be counted. So that's just a small note of the data. Now, I would highlight a few points on this. So firstly, the purple segment is banking and finance. And it's quite clear from these graphs that banking and finance disputes have dominated since 2019 and 2020. And they've continued to do so in these most recent years that we've now analysed. Now, just to pause on that, this isn't a surprising finding, as we said in our last report. Financial institutions and transactions are so often at the heart of these disputes, and one can think of many examples why that might be. It may be that the assets that are the subject of the dispute are held by or passed through a financial institution, or a claimant might be looking to freeze those assets, or a financial institution might be chasing a creditor. They're very often either where the money is or where the money is passed through. And so they're very often in focus. And it's worth saying that other studies have made similar findings. So, for example, the Association of Certified Fraud Examiners produces an annual report called the Report to the Nations, and that consistently finds that banking and financial services is the most affected industry by occupational fraud. So, yeah, that's sort of corroboration for our data. And also, again, colloquially, since our last report in the last couple of years, finance-related disputes have continued to be amongst the most significant in the English courts. And just to think of one example, the Republic of Mozambique against Privinvest and Credit Suisse and others was one of the most major disputes the last 2 years as a financial services dispute, and we'll come to talk about that again a bit later in this seminar. So aside from financial services and banking, on this chart, there are a number of other sectors. And I think what strikes me in relation to those is both that there's a relatively high degree of year-on-year fluctuation, but also that there's a relatively even spread. So, with these sectors, we've got construction and infrastructure, consumer products, manufacturing, professional services, real estate, and technology, media, and telecoms. And it's hard to say really that any of those dominate. And what this suggests to me is fraud is sector agnostic. And again, if you look at other studies like the Report to the Nations by the ACFE, that again, shows that widespread across sectors. So yeah, those are my two takeaways from this data, I think. So moving beyond sectors, onto the next slide, please, Aaron. Okay, so now we're going to come on to the international appeal of the English courts for fraud claims. And I think one of the most interesting takeaways from our report last year, or 2023, was how many nationalities are represented in fraud claims in the English courts. So as I said earlier, Stewarts have reviewed the available claim forms from 2020 to date to try and survey the origins of parties. And that data comes with some caveats. So firstly, we don't include 2024, and that's because there aren't enough claim forms available with foreign parties to draw meaningful conclusions, and our intention is to revisit that in our next report. So we'll have a clearer view then, hopefully. Secondly, the data itself needs to be treated with a bit of caution. So the way we went about it was to look at the parties' residence based on the claim forms, so where their address is. And that obviously has limitations. So, for example, it won't capture English subsidiaries of non-English multinationals. It won't capture foreign individuals with an English residence, or where a contract contains a service and process clause. So we need to be mindful of that as we look at the data. And I think there are also other ways to assess how international a case is. So, for example, when the commercial court looks at this issue, they have their own definition of international, which they define as not domestic, which they then define domestic, helpfully, which is where the subject matter of the dispute relates to property or events within the UK, or the parties, the part of the party's business that is part of the dispute is carried on in the UK. So they have I would say, a broader definition of international, and on that measure, they class 63% of cases in the period October 22 to September 23 as international, rising to 73% if one excludes a big chunk of COVID interruption cases. Now it's important to note that that's for all cases rather than fraud claims only, but it just highlights the fact that there are many ways to look at this issue, and we've sought to work with what we've got to try and look at data and draw some conclusions. And I think the final point I would note in the data is that claimants, and even less defendants, have a free choice when selecting jurisdiction, by which I mean they don't have a free choice. And everyone listening to this will appreciate that a number of factors determine the choice of jurisdiction to enter a claim. We say that there are lots of benefits to the English legal system, and we'll come on to that shortly. But ultimately, contracts have governing law clauses. Wrongdoing happens in certain jurisdictions. Assets are located in certain jurisdictions. So the participation of foreign parties in England does not necessarily reflect a free choice, albeit where there is a choice, there are factors that make the English courts attractive. And we'll come on to that in a second. So against that background, here is the data. And in the first slide, what we have here, well, we have two charts. We've got one for claimants and one for defendants. And the bars show the origins of parties by region as a percentage of all parties. And then underneath, you have percentages of non-UK parties generally. So looking at the claimants, what we see is that since 2020, a third of the claimants roughly have been resident overseas. And then looking at where they've come from, the EU and the USA are consistently the most commonly represented geographies, despite blips in various years, and we'll come on to that. And there's also healthy representation from APAC, the Middle East, British Overseas Territories, and the Americas. Moving on to the next slide, please, Aaron, we come on to defendants. And this shows that about a fifth since 2020 have been from overseas. And the EU is again consistently the most commonly represented, along with the USA, and then there's healthy representation from the Middle East, APAC, and others. So this just gives you a good feel for where parties are coming from. So what can we take from this? I think for me the most striking conclusion is related to the EU. So in our last report, we reflected on the drop-off of EU claimants following the end of the Brexit transition period in 2020, and whether that would be sustained. However, on this analysis, there's been quite a significant recovery for both claimants and defendants from the EU. And this potentially suggests that the longer-term impact of Brexit may be less of a concern for EU parties seeking to litigate in England, or others seeking to sue EU parties in England. That might connect with the ratification of the Hague Convention. We'll come on to that a bit later. But certainly for both claimants and defendants, there is a striking uptick, and it'll be very interesting to see whether that continues in future years. I think my second major takeaway was the lack of Russian parties, and this isn't a surprise for obvious reasons. But generally, it seems interesting to me that there's a relatively low level of Russian parties, even prior to the invasion of Ukraine, for both claimants and defendants. And that may be a reflection of the way we've produced our data, or it might be just a reflection of the fact that actually Russian parties weren't such a significant proportion as was widely considered prior to the invasion of Ukraine. My third takeaway was that there's a relatively low level of African parties, and this touches on one of our pre-submitted questions. And And that surprised me because there are obviously historic connections between some African states and the UK, but they have a very low representation in these claims based on our data. And then my final takeaway is that at a more fundamental level, it is clear that parties from all over the globe are litigating fraud claims in the UK. And in one sense, that's not a surprising insight. And we can guess the perceived benefits. For a long time, English practitioners have had a sense of the UK being a preeminent jurisdiction for litigating fraud claims and offering a number of benefits, be that the effectiveness of worldwide freezing orders and search orders, the sophistication of the judges and the legal system more generally, or the disclosure regime. And that self-image continues to be rehearsed. And there was a very striking passage at the end of the Mozambique and Privinvest judgment last year, where Mr. Justice Knowles very eloquently reflected on the shared confidence in a fair trial from parties from all over the world in that dispute. So we really do have that self-image, and to an extent, I think that self-image is reflected in reality. Worldwide freezing orders are very powerful. This jurisdiction can deal with very complex claims, and the Mozambique case is an example of that. But there are also 2 cases this year that are going to involve year-long trials. One of those cases we have for the claimant. So that self-image is reflected in reality. But to try and stress test those, in the report we speak to a number of our colleagues in other jurisdictions, as I say, to try and stress test those assumptions. And I think, to a degree, our self-image is supported by what they say. So there were comments about the faith that people abroad have in a robust legal process here, the attractiveness of worldwide freezing orders, also the importance of the underlying commercial ties between countries in being a factor of where claims are brought. But there are also some unexpected points. So, for example, there was some confusion about the solicitor-barrister distinction, which is a general point rather than a fraud point. But I think that's an interesting one that the practitioners should be aware of when dealing with foreign parties, about the different roles they play. When we spoke to our Indian colleagues here at Stewarts, there was a sense that claims from India would increase in the UK because of increasing commercial ties and various cross-border investment initiatives between India and the UK. And then the final striking point from those discussions was how other fora are challenging the UK for challenging the benefits that we think we have here. So that was a sense from Singapore, but also particularly from the Middle East. And they reported that the DIFC and the Abu Dhabi global market have really become more sophisticated. So, for example, they made it easier to obtain worldwide freezing orders. They have a more settled position on the reciprocal enforcement of UK judgments, and then also have good crypto asset legislation, all of which makes them increasingly attractive places for parties to litigate fraud claims rather than feeling that they have to come to the UK. So that was a very interesting element to this year's report, and we refer you to the report when published for the full details of those discussions and comments.
The only other point I'd add just very briefly as well is, in terms of attractiveness of the English courts, one of the points that we're often asked about and often features in strategic decisions over where to litigate is the availability of disclosure, and the way it will be run and the way it will be dealt with and the way it will be enforced in different regimes. And that makes England and other common law, particularly jurisdictions, but it does make England a popular choice, and particularly on fraud claims, where often you might have suspicions, but you will need to have evidence, and so you need to think about how you frame your claim to get there. Final point, it is interesting, isn't it, on the Russian claim data that predates, obviously the Russia-Ukraine war. In that it's a relatively low proportion in terms of number of claims. We haven't run analysis on the sort of the value of claims, and I wonder whether we might find, because typically the kind of claims that involved many Russian parties were very high value. It might be that it's a small proportion in number, but a high proportion in value. And I'm afraid we don't have that data, but perhaps we'll look into that for next time. I think we were going to move on to next, covering very quickly some points on future developments that we can see coming down the track, and how they may impact on the volume of fraud claims that are brought before the English courts. And we have a couple of ideas on that we'll canter through to allow a little time for questions at the end. Charlie, I think you were going to talk about the Hague Convention on Enforcement of Judgements, if that's a good time to do so.
Yeah, I think it is, and it connects quite well with what we were saying about the EU just a short while ago, about the uptick in the data from 2023. So in our last report, we noted that the MOJ, Ministry of Justice here in the UK, was considering responses to a consultation whether the UK should sign up and ratify the Hague Convention of 2019 on the recognition and enforcement of foreign judgments in civil or commercial matters. As always with these things, they have very long titles. I'm going to call it Hague 2019, just for convenience, because I'll be referring to another one shortly. Anyway, that consultation in the UK has finished, and the convention is due to come into force this July, on the 1st of July. And this is important because it establishes common rules to facilitate the recognition and enforcement of foreign judgments between contracting states, which will include between the EU and the UK. And that's important because since the end of the Brexit transition period, there hasn't been such a framework. Parties have had to rely on another Hague Convention, Hague 2005, which only provided a framework where there was an exclusive jurisdiction clause and the subsequent enforcement of judgments based on those exclusive jurisdiction clauses, so much more narrow. Whereas Hague 2019 has covers a much wider range of judgments and will get towards restoring the position that was in place pre-Brexit. It doesn't quite go all the way, so there are a few notes of caution. Firstly, some types of disputes are excluded. That includes insolvency disputes and interim measures. That's obviously a major weakness when it comes to fraud claims. It also doesn't address jurisdiction, meaning that there's a risk of parallel proceedings. It will also only apply to claims commenced after the date it comes in, so claims commenced after July. But it is going to be a step forward, and if the UK joins the Lugano Convention, that will be even better. But pending that application, which is still sitting with the EU waiting for consent, it's going to be a step forward, and it's possible that is part of the reason why the number of EU parties has crept up. I suspect it isn't because it only applies to claims that are commenced after July, but there may just be a general, more atmospheric sense that things are improving in terms of legal relations in that sense. So that is, only the first point we want to talk about. Alex, back to you, I think.
Thank you, Charlie. So the next horizon scanning topic that might mean an uptick in civil fraud claims is the introduction of the failure to prevent fraud offence. And everyone will be no doubt familiar with this, introduced, of course, by the Economic Crime and Corporate Transparency Act in 2023. And it's due to come into force a little later this year, in about 6 months' time in September. A quick recap, the offence is that organisations could be held criminally liable if an employee, agent, subsidiary or other associated person commits a fraud, and the intention of that fraud is to benefit the organisation and the organisation did not have reasonable fraud prevention procedures in place. And it would apply to large organisations who satisfy at least two of the following conditions in the relevant financial year, which is that it has more than 250 employees and a turnover of over 36 million and or assets in excess of 18 million. So it will affect a fairly significant number of companies. And on the defences, that there are reasonable measures in place. Reasonable, the defence bites when you have reasonable procedures in place, or if it was not reasonable in all the circumstances to expect the organisation to have any prevention procedures in place, which sounds like a rather high risk argument to try and run, but we'll have to see how that shakes out. Looking at this in the round, the next 6 months, of course, in terms of organisations getting to grips with what they do about this and what is going to amount to a reasonable fraud prevention process being put in place. It has a lot of shades of the Bribery Act, which many of you will remember when it came into force, led to a lot of boardrooms putting in place measures, of course, to address the position, and that's no doubt happening and will continue to happen over the next 6 months. Now, from a litigation perspective, a civil litigation perspective, this is a measure which brings in place a possible criminal liability offence for organisations, and the effect of that ought to be that well-run organisations will have an increased and more robust anti-fraud approach. Now, in the process of course, putting in place those more robust fraud identification and prevention measures, one might expect there to be an increase in claims that will result from that very process in itself. So that's one way this might feed into the civil litigation arena. You can also see it's possible for there to be associated civil litigation arising, especially if there is an increase in regulatory prosecutions of companies under this legislation. It remains to be seen how well the prosecutorial bodies in the UK are going to be funded and how closely they will look at all of this. But of course, greater scrutiny in this area, it's fairly obvious to see how that could lead to an increase in associated civil litigation as a result. So I think watch this space. Charlie, do you want to talk about fraud in the disputes processes?
Yes, I will talk about that. So this is one of the most interesting developments for me, I think, which is there have been a couple of quite high-profile cases in the last couple of years where the disputes process itself has been affected by fraud. Last year, there was a case called Contacts Partners against Kuwait Finance House. And what happened there was that individuals purporting to act on behalf of Contacts sought to enforce a totally fictitious arbitration award against Kuwait Finance House, so called KFH. They copied it from another arbitration award, replaced the names, but it was totally fictitious. And KFH only narrowly avoided it being enforced against them via, I think, a third-party debt order. Very narrowly avoided that, and they were very thorough in their approach to debunking the award. But it was a very close-run thing, and I think is a real wake-up call to practitioners about how these things can crop up as part of the litigation process, and in arbitration in particular. And on arbitration, many in this webinar will be aware of the case of Nigeria against PNID in 2023, which was another similar case. In short, there was a very short 20-page gas supply agreement between the two companies, where PNID was tasked with constructing and operating a gas processing plant, and Nigeria was to supply the gas, but neither party fulfilled their obligation on the agreement, and so PNID commenced an arbitration. And in 2015, a London-seated arbitral tribunal accepted PNID's allegation, and in 2017, they awarded £6.6 billion in damages with 7% interest, And then in 2019, Nigeria sort of challenged the award on the basis of serious irregularity, by which time the amount of the judgment was $11 billion in interest, which is obviously a very significant sum for Nigeria. And ultimately, that award was set aside by a London court, which found that P&ID's legal team had improperly obtained and retained privileged documents, that they relied on evidence which they knew to be false, and that P&ID had bribed a Nigerian official to buy her silence in the arbitration proceedings in relation to bribes that she'd accepted when the underlying agreement was entered into. So it's an absolutely extraordinary case, actually, and I think, as I said, is a real wake-up call for practitioners, to be on your guard when you're involved in these types of disputes. And there has also been criticism of the role of arbitral type tribunals, which I think people generally see as they have a reputation for not intervening as much as a court would do. So that, I think, has also come into focus. Moving on. Should I just take the Law Commission consultation on contempt very quickly?
Go for it. Yeah, please do.
So the final sort of forward-looking thing for me is, as I said, the UK Law Commission is reconsidering the law on contempt, and currently that is essentially based on the common law and has developed in a higgledy-piggledy way and has lack of clarity in what the principles are. And the idea is that this will be rationalised and codified and be easier, I think, both to understand and to apply. I think that based on what has been, based on the details of the consultation, it seems that the impact on fraud practitioners will actually be limited. There'll be more clarity, but it seems like that the underlying principles and punishment will be fairly similar. But I think it's important to be aware of, because it can come into play for fraud claims, for example, where a defendant doesn't comply with a worldwide freezing order or a disclosure order. The ultimate punishment is that they'll be found in contempt of court, and it can come with a prison sentence of up to 2 years. So that is something for people to be aware of.
And the only challenge, of course, you have with contempt of court criminal sanctions is that the sentence is up to 2 years, which means that you're not available for extradition, which in some cases where you go down this kind of road can make it's very valuable, and it obviously means you could never set foot without risk of arrest in the UK, certainly again, if you have that kind of order made against you. But if you are able and willing to simply avoid the jurisdiction, then that can be a challenge, but it's still a valuable point. The final thing I'll touch on very quickly, and then we have one question that we do, I think, know the answer to. So I will answer that quickly. But the final forward-looking point to talk about very briefly is around AI. No good webinar or seminar of any nature doesn't mention AI because it's coming down the track in various different guises. And the short point is, a rise in AI probably will see a rise in fraud claims coming out of that area. And I say that because new technology and new systems, new operations of any sort get targeted by fraudsters, and I just can't see why AI would be the same. We are all in a number of different guises looking at deploying AI in different ways and how it might work, and there will be some ways that work well and some that don't work so well, and inevitably there are going to be areas where this is targeted by fraudsters. There was the very interesting Arup case that some of you may remember, where essentially fraudsters contacted a company's treasury department using deepfake technology, persuaded the individual in question based in Hong Kong that they were the company's CFO, and instructed that individual to make a series of transfers amounting to about £20 million out of the company and into the hands of fraudsters that was essentially lost. That is an obvious way in which AI has been directly used to perpetrate a fraud. So that's a cautionary tale but I suspect we will see AI coming into the fold. Turning to some of the questions, we have a question, which is that in reference to the slight drop-off in claims for 2024, is this something we have observed beyond fraud claims, and do we expect that trend to continue? So, in other words, if I've understood the question, correctly, while fraud claims may have dipped slightly, is that a sort of, tracking a trend in claims generally dropping off? From the data that we've seen, I don't think that is particularly borne out. If we go to 2020, the total number of claims issued in 2020 was 7,317. In 2021, it was 7,644. In 2022, it was 7,257. In 2023, it went back up, 7,684. And in 2024, it dipped slightly, but, consistent, certainly with 2020 and 22, of 7,365. I don't think there is really a meaningful trend you can pick up in those years. It's broadly that number of claims does fluctuate a bit year on year, but it's broadly staying at consistent levels as a whole. So I hope that answers you on that.
And just to add to that, I think colloquially, I feel the disputes market is incredibly busy at the moment. Frankly, both for fraud and non-fraud claims. But obviously, not all disputes reach the claim stage. So it's worth just being aware of that as well. Is that disputes can still be there even if they don't ultimately reach the claim stage.
Yeah, that's a good point. Picking up on another question that I'm afraid I don't know the answer to really, but we'll have a go. The question is, can any assumptions be drawn from next to no apparent fraud claims emanating from Central Asia? The short answer is no. We don't have I don't have anything I can point to as to why that may be. Perhaps those cases are typically being litigated in different courts, of which there are a number of obvious places where that type of case might originate from. But there's no particular thing that I can point to in the data that I've seen or that I'm aware of that underscores that. It is a point, however, that we will take under review, and we might consider it in the final report that we produce to see whether there is anything in the data that either hasn't been picked up or that does point to there being an underlying reason for that.
Yeah, I mean, a few reflections from me on that. Firstly, your point, actually, there might be being this case in other courts, and it's worth noting that there's obviously the Kazakhstan Astana Financial Centre that has its own court, staff and English judges. That's a natural place for these types of disputes to go potentially. One might almost, would also reflect on the fact that, of all the geographies that we discussed, there are potentially fewer historical and commercial ties between Central Asian states and the UK, which makes it a less obvious place for claims to originate from potentially. That's just speculation, obviously. But yeah, a couple of further reflections on that, I suppose.
Yeah, that's very interesting. The final question we had was, we mentioned the Hague Convention will not cover insolvency enforcement. This is a well-versed topic in the insolvency world as to whether an insolvency judgment ought to be sort of directly enforceable. There's already existing insolvency-based reciprocal recognition processes that can be adopted, but they don't include direct recognition of judgments just because they come out of an insolvency process. That is correct. The question we've been asked is what proportion of fraud claims have an insolvency element? We haven't undertaken that level of analysis in terms of the data. It's something we will take under review and see whether that can be, relatively easily carved out. One of the challenges with doing that is, a simple approach would be, I suppose, to look at claims that are brought in the Insolvency and Companies Court. But of course, many insolvency-related claims, and it depends what you mean by that, but if we talk about claims brought by office holders, insolvency office holders, I suppose, those claims are not always brought in the ICC. They're often brought, particularly the big ones, in the commercial court. So, we're running several which follow exactly that model. So we'd have to think about, what metrics you would look at to deal with that. Colloquially, what I would say is, a fairly significant number of fraud claims do have an insolvency element. A lot of the litigation that comes out of corporate or personal insolvency, as well as corporate collapses, are claims where what is being alleged is that assets have been wrongfully and in many cases dishonestly taken from one estate, the company or personal bankruptcy estate, and have been put elsewhere when they shouldn't have been. And those are essentially fraud claims. So colloquially, I can say that a significant number do. The insolvency space is fairly fertile ground for fraud claims, but I'm afraid in terms of actual data, we don't have that to our fingertips, but we'll see if we can do something about that. I don't believe we have any more questions that have been put to us, in which case I think all we can do is say thank you to those who've dialed in and listened, and I hope it was relatively interesting.
And thank you, Alex. Thank you, Charlie. An incredibly interesting hour. So thank you very much for your time. Pleasure to have you with us. Hope we can do this again. And thank you also to our audience for being with us and for those questions. If you do have a question, you can see Alex and Charlie's information in front of you. Please do get in touch. But once again, thank you, Alex. Thank you, Charlie, for today. We hope to see you again soon. Hope everyone has a lovely rest of your day. Bye.
Thanks, everyone.